Good morning, Judge Shapiro. I just want to let you know that we have the attorneys for both parties as well as the court reporter, and I can bring them in whenever you're ready.
All right, I'll need a couple of minutes and I'll get right back. Morgan, I'm ready to begin.
Okay, I'll bring them in right now.
Thank you. I think you've got me locked out of the video. Aha, okay, there we go. Good morning.
Morning, Judge.
Morning.
Morning, Ms. Mahoney. All right, very good. Well, anything preliminary before we go on the record? Okay, all right. All right, I'm going to call the case of Elizabeth Cady Stanton Trust versus Dana Nessel in her official capacity, docket 22-66-MB. And this is the defendant attorney general's motion for summary disposition. So Ms. Mindgast, we'll start with you.
Thank you, Your Honor. Assistant Attorney General Heather Mindgast on behalf of Attorney General Dana Nessel. I know the court's read all the briefing and is fully aware, and I don't think there's any need to really belabor the arguments too much this morning, as they're pretty straightforward from our briefing. The Attorney General is a big supporter of the Equal Rights Amendment and of women's rights in general, as is demonstrated by our, filing of the amicus brief and the DC Circuit case that is ongoing. But, this philosophical unity, I think, sort of demonstrates why there's a problem with this case and why the Attorney General is not the appropriate target. In this case, in count one, the trust seeks a declaratory judgment. They seek a declaration that the ERA amendment is a valid amendment to the Constitution and thereby enforceable against the state of Michigan. Now, as this court knows, in order to obtain declaratory relief under MCR 2605, the trust must demonstrate the existence of an actual controversy between the trust and the Attorney General. And generally that requires showing that there's an adverse interest between these parties that requires sort of the sharpening of the issues raised, and that a judgment is somehow necessary to guide the trust's conduct, its future conduct vis-a-vis the Attorney General. And their argument or their injury or their controversy, as they have phrased it in their pleadings, is that the Attorney General is somehow obligated or has a duty to ensure that all Michigan laws, policies, programs comply with the ERA. And as we've argued in our brief outlined, that just isn't true. That isn't a duty that the Attorney General has under our state constitution.
Ms. Mindgast,
Yes.
is the you said that the Attorney General intervened. Is that in a case seeking to have the ERA determined to have been adopted?
Yes, in the DC Circuit case, which is on appeal in the Court of Appeals out there. Sorry?
What is the name of the case?
That case is, I believe that is the Virginia versus Ferrero.
Oh, yeah, I got you. Okay, thank you. That's already gone to the circuit court. You mean it's on appeal to the Supreme Court?
That is on appeal at the Federal Court of Appeals at the moment. They had argument in September. And
I must have missed around because I'm looking at the decision from June of 2021. That's Ferrero, something like that? Mm-hmm. Okay, well, obviously something has happened since the last printout I have. Okay, you can.
Okay, so going back, right, the existence of an actual controversy between the trust and the Attorney General. But, the Attorney General, she is not the maker of laws. She can't fix the laws. That would be the legislature, nor is it really her duty or capacity. She's not the enforcer of laws at the executive branch level, right? That's the state, and that's the governor's office. The governor is the chief enforcer of laws in this state. It's the governor who supervises the executive branch departments, sets policies for those departments or programs, and has the ability to control the behavior of the executive branch departments that she supervises. So we're really not, the Attorney General doesn't have the ability or the duties to sort of make the remedies here or provide the relief that the trust is really seeking in this case. She has lots of things that she can do. Her principal duties is to represent state departments and officers when they're sued in court. She has the ability to take action in the name of the public to protect the rights of the public. She has the authority by statute to offer legal advice, offer opinions to state agency clients in the legislature, but she doesn't have the duty to overhaul or to look at every state statute and determine whether it is violative of a particular constitutional amendment. And she certainly has no duty or ability to remedy those laws by fixing them. So so there just isn't the type of controversy between the Attorney General and the trust that needs to exist to support a claim for declaratory relief. It's even if the court thought somehow that the Attorney General was potentially a target, or there is some role in here, the problem here is that we're still missing necessary parties. So, the grant of declaratory relief is entirely discretionary. So it's still discretionary, even if the court thinks that there's an actual controversy, it still remains discretionary. And it's also, so the court would have the ability to deny relief on the basis that we're missing important parties to this case. So even if we're a target, I think you're missing the state of Michigan or the governor sitting in as the state, and you're missing the legislature. A grant of declaratory relief in this case would only bind the trust and the Attorney General. And so you're missing the other parties who would be capable of carrying out the relief that the trust is seeking, amending laws, changing programs, all of that. So a declaration as to the Attorney General would provide little in the way of any relief. And so even if the court thinks that there is some type of controversy between the trust and the Attorney General, the relief that they're seeking would really not be remedied through simply declaratory judgment against the Attorney General. So I think for those reasons, there is no actual controversy between the parties. And even if somehow there is, that we are not an inappropriate party to have in this litigation, we're missing the parties who can actually remedy the injury that the trust is asserting.
Let's assume you're correct on that last point. Would that mean that this matter would be dismissed, or that somehow we would have an opportunity we could grant an opportunity to bring in these other parties?
Well, my first point would be, I do think that we don't belong in the lawsuit, but if the court thought that this could be remedied by bringing, that would be up to the plaintiff up to the trust to determine whether it wished to do that. Also, setting aside the big point that none of us really addressed is this court, does it have the jurisdiction to declare an amendment?
Well, I noted that the merits were not in your brief, really.
That's correct, Your Honor. I mean, I thought, I mulled that over. It's something that we certainly could have argued. I think that's a great question for plaintiff's counsel. Looking again at their complaint last night, it really was bereft of any sort of explanation as to this court's jurisdiction to declare an amendment to the U.S. Constitution valid.
Well, given the Attorney General's position in this other case, I'd be surprised if she wanted us to make such a declaration. that it wasn't valid.
That it was valid?
I would be surprised if she wanted this court to make a declaration on the merits that it wasn't valid.
Yes, I mean, I think that certainly the appropriate place, the federal courts are certainly, I would think, a more appropriate venue for this significant question. Could this court, in theory, this court, like any state court in Michigan, has the ability to interpret the federal constitution and apply it in a case before it. Like lots of plaintiffs come to you probably and say this statute's unconstitutional, it violates First Amendment. The court can interpret the First Amendment and apply it to a case with the facts at hand. Does this go farther by having to sort of declare a piece of the, a piece of the federal constitution to be valid? I'm not sure that's really the same as interpreting and applying federal law and federal constitutional law to a case. But, setting that all aside, the big problem here is that we're not the right target. The Attorney General is not the right target for this litigation. And I think it probably goes without saying that that the better venue for this kind of decision would be a federal court that would sort of resolve it at a federal level instead of.
But I agree that would be a better venue, because this is the wrong venue.
Yes. Again, I think this is a good question for plaintiffs. Can the court, with your ability to interpret and apply the federal constitution, make a declaration that the ERA is valid? I didn't answer that question, Your Honor, because we chose to look at and argue that there isn't a controversy here between this particular defendant, between the Attorney General. And even if there is some sort of reason to keep her in the lawsuit, we're missing important parties. We're missing the state. We're missing the lawmakers. So. Okay.
All right. Well, you have something else now, or you want to just wait to have a few minutes of rebuttal?
That's fine. The mandamus claim would fail for the same types of reasons. I mean, we don't have a duty here. There wouldn't be a clear legal duty or clear legal right to the. Right.
I mean, whether this is a ministerial act,
and whether it's ministerial for her to engage in the conduct they wish to compel. So sure, no, I'm fine, Your Honor. I can save some for rebuttal.
Okay. All right, Ms. Mahoney, could you begin by and it probably was in your complaint, just reminding me what the Elizabeth Cady Stanton Trust is?
Yes, Your Honor. The Elizabeth Cady Stanton Trust is a trust set up by the descendants of Elizabeth Cady Stanton, who was a very, very important figure in the history of women's rights. The express purpose of the trust is to enforce women's equality wherever and whenever they find a need to do so. The National Organization for Women, and I'll get to this in my argument a little bit, the National Organization for Women has a sort of very broad purpose, and there's many things that initiatives that now has under the statute. Elizabeth Cady Stanton Trust, on the other hand, exists solely to support efforts to achieve women's equality throughout the United States of America.
I'm sorry, go ahead.
That's the trust's entire purpose. The one of the major players is Colleen Jenkins, who is actually the great-great-granddaughter of Elizabeth Cady Stanton. Also participating is Marsha Weinstein, who's the executive director. And then Wendy Murphy has also assisted in the drafting of pleadings and the formulation of the arguments. I owe her a lot of credit. She's a professor at the New England School of Law, a very esteemed and worthy advocate for women's rights throughout the United States.
What is her name again?
Wendy Murphy.
Thank you. So, and one other question before you turn to the issues, which is the trust litigating this issue in other states or other courts?
There were two similar complaints filed in the state of New York against Letitia James, and in the state of Rhode Island against their attorney general, whose name presently escapes me.
Okay.
But I know that it was
those cases, if you know.
Those cases are also at the preliminary dispositive motion stage. I believe those are still being briefed. Somehow the state of Michigan got first to the finish line to get to an argument on this issue, but there are similar motions pending in both Rhode Island and New York.
Okay, thank you. All right, now you can proceed to the substance of your argument. Thank you.
I appreciate it, Judge. And just so it's clear for the record, I am Mary Mahoney, appearing on behalf of the plaintiff, Elizabeth Cady Stanton Trust. We begin this in a sort of simple place, is that engraved on the west facade of the United States Supreme Court are 4 words: equal justice under law. But these 4 words have never really applied to women in America, and more particularly in the state of Michigan. They don't apply to me. They don't apply to my very gracious and learned opposing counsel, Ms. Meingast. They don't apply to the defendant, Dana Nessel. They don't apply to Governor Whitmer, not even to the Vice President of the United States, Kamala Harris, because the individuals that I just named are women. And women have never enjoyed true equality under the law codified in the ERA. This July, in fact, is going to be the 100th anniversary of the ERA. It was initiated in 1923, just 3 years after women were granted the right to vote. And that was in the 19th Amendment. It was not approved by the United States Senate until 49 years later, and then sent to the states for ratification. Michigan ratified on May 22nd, 1972. And that was through the good efforts of Martha Griffiths, as was pointed out by AG Nessel in her amicus brief in the DC case. Ratification of the ERA actually did occur in 2020, when the 38th state, Virginia, finally ratified the ERA. So this case is about seeking relief by way of mandamus to require Michigan's Attorney General to bring the laws of the state of Michigan into compliance with the equality that's guaranteed in the 28th Amendment. The substance of our case is not challenged here, and this court is duty bound to presume that we can establish that, in fact, it's ratified and valid. The AG's motion challenges 2 procedural issues: standing and the availability of mandamus as a mechanical tool for us to get there. In this case, we're not claiming, I guess, pure organizational standing. We're alleging that we have standing under the case known as Idaho versus Freeman in the Ninth Circuit. And in that case, the court found that there was a protectable legal interest in the subject matter of the proceedings and granted the National Organization for Women full party standing under Article 3. Now, importantly, that decision has never been overturned or criticized as to the standing issue. Ms. Meingast, because she is detailed and thorough, notes that it was later vacated and deemed moot, but that was on other substantive grounds. Now's standing was left undisturbed completely. It was implicitly approved by the United States Supreme Court, which never questioned Now's full party standing under Article 3. They had to have standing in order to even petition the Supreme Court for a writ of certiorari. Now, even if the court chooses to ignore the Freeman case, we also see that the Judge Contreras, I think his name is, in the DC case, he granted standing to 3 states that were decidedly anti-ERA and gave them full party standing under Article 3. And he did that because in that case, he found that they would be harmed by validation of the ERA, because validation of the ERA would require them to bring their state laws into compliance with ERA. So what we're saying is that if he was correct in doing that, then the Elizabeth Cady Stanton Trust has standing in this case because the injury goes both ways. Now, we could wait until an actual woman steps forward alleging that she's been harmed in some fashion by one of the statutes that we
It'd
claim.
be hard to find somebody.
Yeah, well, you have to go looking these days, and everybody is engaged in other things. But if the amendment of the Constitution is not like other kinds of lawmaking, and you note that the Attorney General in this case, Ms. Nessel, post Dobbs, she came out almost immediately and said that she would not be enforcing any laws that criminalized abortion in the state of Michigan. So she used her discretion in that case to indicate that she was not enforcing. So here's the crux of the standing issue, I think, falls on the fact that this court is a co-equal court under Article 5. Any reading of Article 5 tells you that the power was distributed equally between the federal government and the states. The states are the avenue through which the people speak, because every person in this country lives in a state or a territory, and they speak through the state, which is granted a co-equal power under Article 5. It specifically empowers the states to have a say in the process of amending the Constitution, and it distributes that power equally. Any contrary insertion would just sort of disrupt the balance of power between the state and federal governments. I don't think the AG wants to be heard to say that the federal government can come in here and push us around in interpreting the Constitution of our state as well as the United States. What remains true is only the courts can determine the validity of the amendment. And that happens through the powers enumerated in Article 5. There's only two requirements, Judge. One, that Congress passes the amendment, and two, that the states ratify the amendment. And that has now happened. So now we come to the mandamus portion of the brief, and this is the one that I find a little bit bemusing, and I acknowledge that we did put AG Nessel on a bit of a tightrope here, because in order to prevail on this motion, she must allege and prove that she has no duty at all to act in the face of a valid constitutional amendment. The plaintiffs, of course, believe in the Attorney General, and we're asserting that the executive branch of the state of Michigan's government not only can, but they must bring the state into compliance with the ERA.
What does that mean?
Well, again,
let's assume I were to rule in your favor. As a practical matter, what's going to happen besides going up to a higher court?
Yeah, that's an obvious. The specific steps aren't clear, and the specific steps, I think, are based on more or less a resource allocation. And maybe some discovery would help us illuminate that. But I think what is clear is that doing nothing is not an option. And that's what the AG is really asserting here, is that they have a duty. They don't have a duty to do anything at all. And to me, that sounds like the collapse of democracy in the face of a constitutional amendment. Because if states didn't have a duty to obtain compliance with the constitutional amendment, where does that leave us? Then no change could ever be effectuated if states got to pick and choose which ones they wanted to bring into compliance and not. And that's simply not the way we've ever done anything. In the entire history of our country, no state has been permitted to do nothing at all after ratification of a constitutional amendment. It would be a constitutional crisis, I would say, if that were the case. The statute itself, the ERA, gives the states 2 years to bring themselves into compliance with the 28th Amendment. And there's nothing in that even suggests or implies anything about discretion. I want to point out that the seal of the Office of the Attorney General, as does the state seal, and it's on the seal that we see on the Zoom conference right now, it appears the word tuebor. And that's what struck me when the seal popped up this morning. Tuebor is a Latin word. And what it means is I will defend. And the AG's oath of office, in fact, states that she is going to support the Constitution of the United States. So she's saying that today she can't be compelled through mandamus because the action is discretionary, but the requirement that she support the Constitution and any amendments to the Constitution is clearly not discretionary. The actions that she recites in her reply brief of, when to survey laws, how to identify suspect laws, how to decide whether they in fact discriminate against women, those specific things may be discretionary, but you have to keep in mind the Attorney General is she's not deprived of law enforcement ability. In fact, she is the chief law enforcement officer of the state of Michigan. No one's saying her job isn't difficult. And what those ideas and what those basic premises suggest is that it's going to be tough for her to allocate resources. But it doesn't give her discretion to not enforce the law. We're saying, of course, there's a duty. Of course, there's a duty. And mandamus is the only vehicle that we have available to enforce that duty.
Can you explain to me, I'm sorry if it seems overly simple, what does it mean to enforce the ERA from the position of the government as opposed to, a civil matter?
Well, it means to bring all of the state laws into compliance with the requirements of the constitutional amendment, in this case, ERA. There were
Can you give us an example of a defective state law under the ERA? It's not a quiz. I'm just curious to try and get an impression.
There were a few that were recited in my complaint, which I neglected to pull up in front of me.
Oh, that's fine.
Substantively, I did recite a few in the complaint, and the criminality surrounding various abortion issues certainly always comes to mind. But there are others. Those are not exclusive. This is not an abortion case per se. I know that Ms. Meingast's desk is littered with cases about women's reproductive rights. This is not that case. We're talking about a bigger, broader issue. So, what it comes down to, I guess, is what if a state attorney general's office has all the discretion? Would they be allowed to no longer require their state laws to comply with the 13th Amendment? Would mandamus be appropriate in that event?
Mm-hmm.
Could mandamus be used by a 19-year-old if Florida raises the minimum voting age to 65? Now, there wouldn't be many books to show them how to deal with that issue, but certainly I think that mandamus would be the only appropriate vehicle for them to do that. The Attorney General's argument here is that if a state legislature simply decides not to comply, then the Attorney General is the chief law enforcement officer, has no duty to do anything at all because any action would be discretionary. I think the harm to democracy in that statement is fairly obvious. We're not suggesting even that the Attorney General is the only official who must take action to uphold an amendment. What we're suggesting here is that she's the one best situated because she is the chief law enforcement officer. She has the power to direct agencies. She has the power to render decisions to other officials consistent with the law. If requested for advisory opinions, there are numerous advisory opinions that are issued by the state attorney general's office. We're not suggesting here that the AG commit resources to correcting a bunch of typographical errors in the law books, changing he's to she's. That's not what we're talking about here. Laws are only part of the problem. The laws codifying civil rights for women are still enforced differently and worse than other anti-discrimination laws. So there's programs, there's policies, and all of these fall under the bailiwick of areas where the AG has the authority to instruct and advise and direct. The AG doesn't change laws, but she most certainly has a role in advising and instructing the legislative bodies and agencies that are charged with enforcing the law. I think it's premature to dismiss this case based on a lack of duty without at least providing an opportunity to explore the role that Michigan's Attorney General had in enforcing compliance with, for example, the 18th Amendment when Prohibition came to Michigan. We know the boats kept running across the river, but what role did the Attorney General have in that event in making sure that Prohibition was enforced in the state of Michigan? And what about the 26th Amendment? Weren't there things that needed to be done to make sure that 18-year-olds could appear at the polls and hand their cards over and vote? So, again, we can wait until there's a specific woman that suffers harm, but
Isn't that all public record?
It would be public record, yes. It certainly would be, and I think it would be available, I think, from, historical tomes that I'm not usually vested with a lot of time to read those, but certainly we'd be entitled to discovery to provide a proper framing as to what the Attorney General thinks her role is in this case, if any. I believe she's now asserting that she has absolutely no duty at all. We think that that's a logical conundrum. We don't see how she can get to having no duty at all to enforce a valid constitutional amendment. So it's kind of a rare and important case. It's unprecedented in this set of circumstances. It's not like we can look at a previous situation where this thing happened and said, oh, well, the last time this happened, here's what we did. We don't have the benefit of that. This is a rare and special case. And what I'm saying to the court is essentially, you're a judge too. Under Article 5, you are a co-equal court. You have the ability and the authority to give those words meaning on the side of the west facade of the United States Supreme Court. Michigan could take the lead in this event and put this issue right into the sunlight and allow some discovery to illuminate the power and the authority of the Attorney General to direct and advise its legislative bodies and state agencies that it works with. We're not saying that any of those is over the other one, but they do interact. They do have roles together. The AG is not going to be heard to say that she's not allowed to tell the legislators that, in her opinion, they can't do that. What effect they give to her opinion is an entirely different matter. But as evidenced by actions taken not only by this Attorney General, but by many prior Attorney Generals, they do have the ability to go to the legislature and say, you can't do that. And they have exercised that authority on many occasions. Now, this Attorney General voiced her support for the issues raised in the case against the United States Archivist. But again, they're relying here on the same type of procedural argument that resulted in Judge Contreras ruling against the states. It's a procedural issue, which is the equivalent in Michigan football land of a punt. In doing so, what Judge Contreras specifically held is that the action demanded of the archivist is a formality with no legal effect. So he denied the state standing because the archivist's failure to publish the law causes no harm. We can't say that the same is true here. With the failure to enforce equality impacts all of the 10 million residents of the state of Michigan, and more particularly the percentage of those residents who identify as female, which according to the great Google is approximately 50.8%. So more than half of the residents of the state of Michigan are impacted by this court's decision.
I've got a question, a practical. I'm a little confused on this Ferriero case. I have a March 21 decision from Judge Contreras, and then I have a decision of the First Circuit 3 months later in June of 21. Is there's something else that sounds like that's happened since, and I don't have it in front of me. Can you refer me to what that might be? I mean, I'll shepherdize it, and that might just tell me, but I'm confused a little bit about it.
Okay, let me see if I can find it. I think our brief was filed right around The
You have a
time,
case number? Is it 20-1802?
that must be it. Yeah, I'm searching.
Oh, no, I'll find it.
So the standing decision was actually a separate decision that was issued before the final dismissal order. I think it was two different cases.
Okay.
One was a Massachusetts case and the other one was a District of Columbia case.
I'll to look at them all.
I can, yeah, I apologize, Judge. I could get those sites and send them to your clerk.
No, it's not necessary unless I'll have somebody call and ask, but there shouldn't be a problem. I just didn't realize it didn't print everything.
The DC
Okay.
case, though, is still pending in the Court of Appeals. And Ms. Mindgast is absolutely correct about that, which I knew she would be.
In the DC circuit?
Yeah.
Very good. Is there anything else you wanted to cover, Ms. Mahoney?
No, Judge, I mean, it boils down to that. I mean, I think that we don't need, when there's 5 million people that have a vested interest in this, I don't think we need to wait until one of them comes forward and says that she's been harmed when the Idaho versus Freeman case clearly gives full party standing to people situated just like the Elizabeth Cady Stanton Trust, whose sole purpose in existing is to assert women's rights and try and get guarantees of equality for women.
Thank you. Ms. Mindgast, anything you want to touch on in response regarding standing or mandamus?
Sure, Your Honor, just briefly. So going back to the standing issue, in the cases that Ms. Mahoney said, the Idaho versus Freeman case and the Ferrero case, again, federal standing principles don't apply in our state courts anymore. We don't follow Lujan, but be that as it may, I mean, if you look at the Idaho case and the Ferrero case, you're talking about cases where states are the parties, either on both sides or at least on one side. There's states suing the archivist, or they were states suing states. So they're just, those cases are just simply not helpful, because our whole point is that we're not the right party. We're not the state. And those other cases.
What about now in the one I'm having trouble with?
Case. So that's the Idaho versus the Idaho versus the Idaho versus Freeman case. Now it was allowed to intervene as a defendant in that case.
I see.
So they intervened on the side of the archivist. So the case was brought by states against the federal archivist, and now was permitted to intervene as a defendant. So it's not the same situation here, because again, you have arguably a case that was postured correctly, right? A state suing the archivist, or at least, of course, the Ferrero case just said that states can't sue the archivist. There's no standing for those states, and that's what's on appeal. But those cases that Ms. Mahoney said just simply aren't helpful, because I think they demonstrate that the proper parties, if there are some, are states. The states ratified the amendment. The Attorney General didn't ratify the amendment. The states have an interest in determining whether they properly ratified or not, what the effect of their ratifications are. So I think on standing, we're still back to our argument for an actual controversy here between the trust and the Attorney General. It simply doesn't exist, and those cases are not on point and not particularly helpful. On the mandamus issue, it's.
Oh, hold on a second.
Sure.
Yeah, go ahead. No, it just froze for a second, but there you go.
Sorry.
You're good.
Again, the question here is, does she have a duty for mandamus to lie? There has to be a clear legal duty for the Attorney General to take the actions they want to compel, to somehow, run a scan across all state laws, policies, and programs and somehow fix them. we know that the Attorney General can't fix laws, policies, and programs, right?
Well, let's take the example that she gave of the 18-year-old who wants to vote in some county somewhere in Michigan. They're not allowing people between 18 and 21 to vote. Could a mandamus claim? Obviously, one could lie against the county officials, but could there also be one involving the Attorney General?
I don't know how there could be. It's the same. Does she have an obligation to run around and try to enforce laws in every court? That's not what her role is under our Constitution. Her principal role is to represent the state. It's to provide advisory opinions as requested by the parties. It's to, take particular actions to protect the interests of the people by intervening in cases or potentially bringing cases. I wouldn't say that there's not a role for the Attorney General if the ERA is valid, if it's enforceable, if the state has to start looking at itself and its laws. Is there a role for the Attorney General to help, to assist, and play a role in that process? Sure, we can assist and play a role in that process and help identify things. But, it sounds to me like what Ms. Mahoney is suggesting, that either the Attorney General has the obligation to file dozens of lawsuits or some giant lawsuit declaring statutes unconstitutional, which would be fairly unprecedented because typically our job is to defend the state, to defend state statutes and policies and programs. Or the other thing that I heard suggested was, well, it's our job to simply render advisory opinions, to provide advice that nobody has to listen to. And so I don't see how either of those approaches are duties, or it can be fit into a mandamus test. It's hard for me to understand what would be the relief, the purpose of the relief to just have the Attorney General render advice that, the legislature doesn't have to abide by, the executive branch doesn't have to abide by. So the relief is, that's what they want. That doesn't seem very effectual, and it doesn't seem like it doesn't remedy what they want accomplished, which would be to strike down or correct laws, policies, and programs that violate the ERA. So I think, again, for purposes of mandamus, the actions that they want to take aren't within really our authority because we can't fix things. And, again, this would be ministerial in the sense that, providing some sort of wide scale scope of looking at laws and policies and deciding which ones to look at, which ones don't, which ones might be violative, which ones may not be. I mean, none of that would be ministerial.
Mm-hmm.
A ministerial function that can be compelled through mandamus.
Okay.
So that's
anything else?
No.
Your Honor, may I just?
Yeah, you can have another shot, sure.
I guess the part of the conceptual problem that I'm having here is if the states have no standing and women have no standing to compel compliance with the ERA, who is defendant Nessel suggesting does have standing? I guess
the women have standing. Has there been a ruling that individual women don't have standing to do so?
Well, I mean, they're suggesting that the trust, which is attempting to enforce the rights of women, doesn't have standing. We're not asking for organizational standing in its purest sense. As I said, we're looking for the same standing that the National Organization of Women got in the Freeman case. The Attorney General also brought suit or filed an amicus brief in the DC case, at least. If the Attorney General could file a lawsuit against the archivist, then doesn't it follow that she could also be sued for not bringing laws into compliance?
Mm-hmm.
And it clearly, in order to bring that case, she's enforcing the state's right to proceed, as is consistent with her statutory duty.
Ms. Moen, do you agree that a declaratory judgment would only bind the parties?
I do believe that, yes, it could be challenged in other places as not being binding on anyone other than the parties to this case. I can see an argument there, but, you know, again, these rights don't exist in a vacuum. And when we're asserting that women have equality and equal rights, 38 states agree with us. Many attorney generals agree with us. This particular defendant agrees with us. And yet we're still fighting these battles. And I quite frankly just don't understand it. If the attorney general can sue, then they can be sued. It just, to me, seems like a logical conundrum, as I said before. I think that was all I had in my notes. It's an interesting, powerful, and rare issue that we are dumping in your lap today, Judge Shapiro. And I go back to saying, you know, equal justice under law, and you're a judge too. You have the right to do this.
It's my guess you get the last word.
All right, good job. Our argument isn't that the trust doesn't have standing to bring a case. Our argument is they have brought the case against the wrong defendant, that there is not a controversy between the trust, an actual controversy between the trust and the attorney.
Who would be the right defendant in Michigan?
State of Michigan, governor, House and Senate.
Okay.
Both, all of the above. Right. So we have not argued that they do not have the ability to bring a case. We're arguing they brought it against the wrong persons. And as far as this idea that, well, we can sue somebody, so then we should be sued, that then we in turn can be sued. We haven't sued the state, we haven't sued the federal archivist. We participated as an amicus in the federal case, right? And it's unclear that the attorney general would have standing to sue the federal archivist to bring these claims. Again, I think that is the role of the states. That's why you have the states as principally the parties in these cases. So I think that that's just sort of a circular reasoning that doesn't even work here. So we would ask that the court grant our motion for summary disposition. Thank you.
Thank you. Well, thank you both very much. It's certainly an unusual and interesting case. And I'm going to need a little time to go back and look at things. And I'll issue an opinion in order, hopefully before too long, but you've given me reasons to go back and reread some things, so I'm gonna do that before ruling. So unless there's anything else.
No, we appreciate all the time you gave us today, Judge. Thank you.
Thank you.
Oh, absolutely. So the hearing is concluded, and I will hopefully get you an answer before too long. Thank you very much.
Thank you, Ron.
Judge.